In Illinois custody cases, winning isn't about who's the loudest in court. It's about who's the most prepared. And the secret? Making the judge's job easier. Now, judges deal with complex family situations every single day. So you showing up with a clear, professional, and reasonable case can make all the difference. My name is Jeff Hughes, and I'm the lead attorney at Sterling Lawyers, and our 25 family attorneys are focused on family law, which gives our clients a huge advantage because we see hundreds of cases each month. And in this video, I'll share with you 5 tips that will help you present your best case and do what's right for your children under Illinois law. So stay with me. By the end of this video, you'll know exactly how to handle your custody case. Okay, before I get to these 5 important tips, it's really important that I set a context for you so you can have a broad understanding of how custody works in the Illinois courts. And at first, it starts with the term custody. Now, that is technically not the legal term. That's not the right phrase that the Illinois judges will use, but it's the word that I'm going to use in this video because, well, we all really understand it and can relate to it pretty easily, but the technical term is a mouthful, and here it is. It's called allocation of parental responsibilities. Now, this term encompasses the legal authority to make significant decisions regarding your child's life, such as healthcare, education, religious upbringing, custody, or in this case, allocation of parental responsibilities can either be joint, meaning both parents share in those decisions, or they can be sole, meaning one parent has the decision. Or it could be a hybrid where one parent has decision-making over one section of those major decisions and the other parent has discretion and can make the decision for the other one, or a blend of any of that. So understand, custody is decision-making. It's the same thing as what the judges are going to call allocation of parental responsibilities. Now, also, let me add another term and make it a little bit more confusing, and this is called parenting time. Parenting time refers to the actual time that the child or children are with their mom or their dad. That's the parenting time that that parent has with that particular child. That's different from custody. That's different from the allocation of parental responsibilities. That stuff is all about decision making. Okay, so I hope I'm being clear here to help understand and get a feel for how the judges are going to be describing and making decisions for your case. Okay, one more important thing before we get going to the 5 tips, and that is it's real important for you to have an understanding of the judge's perspective. The judge is your audience. That is the person that you will be trying to convince, trying to persuade, trying to get to rule and issue an order that's in your children's best interest and that supports what you're asking the judge to do. Okay. Now, the judge is bound to follow Illinois law, and you can look this up certainly on other sites and so forth, but the Illinois law for divorce is found in 750 ILCS 5-602.5 all the way up to 602.7. That's where the important stuff is at for you to go read. So it's real important. Before you get to court, you need to have at least an understanding of how that law is laid out. And it may not be super clear in some areas, but read it because there's some very important factors in there for you to have an understanding of. So that's what the judges will be making their decision through that. Now, that's the law. That's important. I get all that. That's real vital. But the judge is also important because the judge interprets your facts under that law. So the judges can be persuaded, and it's important that you go in with your best foot forward to do just that. Okay, now that I've set the context with giving you the terms and helping understand the law that the judge is going to be working under, let's get to the 5 tips. Tip number 1, present a clear roadmap. Now, the roadmap in family court is called your parenting plan. So think of it as a GPS system for your entire case. So instead of going into court and giving the judge a bunch of real jumbled facts, you want to give the judge, who's already very busy looking at a ton of different cases, you want to make it so easy on this judge that when you go in, you give the judge your parenting plan, your case roadmap. Now what you're doing is you're giving the judge turn-by-turn directions to get to the decision that you want the judge to get to. Okay, so here's what this looks like in real life, in the court practice. So you're going to start with a clear overview, okay, broad strokes. Judge, this is what I'm looking for. This is what I want for my custody, which is the allocation of parental responsibilities. You're saying, Judge, here is who should be making the decisions, the major decisions for my child, okay? So you're explaining that all out there, making it kind of the headline sort of stuff. And at the same time, you're also saying, and for parenting time, Judge, this is the schedule that I want the court to follow, and here is why. And you're going to tie your schedule requests directly to what the law says. Now, the judge is looking at the law, looking at all the best factors that are in the law that I cited earlier, and the judge is weighing your requests against those things and against the judgment of the court. Okay, so now, for example, if you're seeking a majority of the parenting time, you need to be able to explain exactly why this is in the best interest of your child. Now, that could look like maybe you offer more stability from a school and educational standpoint. Maybe it's because in your situation at home, you have more community connections, more connections with extended family members, or maybe you're more cooperative with extended family members. Whatever the case is, you want to be able to demonstrate very clearly to the judge, Judge, I think I should have more parenting time, and here's why. Not just my desire or what I want, but here's exactly why the court should rule in my favor or in the favor of having the children with me the majority of the time. And then list those out there very clearly for the judge to see and understand as to why that should be. It can be very tempting here, okay? That you just want to give every single fact and every shred of evidence and everything out there to support your case. Now, like, that may feel helpful, and it may feel like it's very important for you to get that out, but there's a balance to be struck here. And it's important that you keep it simple and concise and to the point. So use your best evidence. Use the best reasons, the most compelling reasons, the most persuasive reasons of anything you can muster, and make them truthful, but put them in there. Not every single detail. Keep the best ones. So under each point, maybe it's best to keep it between 3 and 5 different really strong supporting reasons for why the children should be with you. Okay, I'm giving you big examples here because I want you to have an understanding going in there. You need to tie it to the law, but you need to keep it simple. All right, tip number 2, build an organized evidence trail. Remember, these judges are busy. They're seeing tons of cases every single day. They just get overwhelmed when a client comes in or a litigant comes in and dumps a ton of evidence on the judge's desk or in front of the judge and just doesn't organize it, doesn't spend the time to edit it down to make it clear and concise and simple. So this starts with having an organized evidence trail. Now, when I say evidence, I mean that could be testimony, that could be facts that you will testify to, it could be documents. And to organize this properly, it is the best practice to do it chronologically. And what I would recommend is that you put it in a 3-wing binder with tabs that are clearly delineating certain milestones in your case, certain timelines in your case, or whatever it is, but make it chronological, starting with the oldest first and working to the most recent facts, evidence, documents, etc. So the judge can look at that and understand, here's what the client's looking for, and here's the evidence to support that. And it's clear, it's organized, I can get to it, I can find it, I can follow it through. That is so helpful to a judge. And if the judge has to weigh between an organized evidence binder, an organized parenting plan, and one that is jumbled and just all disorganized and incoherent and jumps around, the judges can get overwhelmed and say, you know what, this is simple, this is laid out for me, I'm going to be more persuaded over here. Now, when I talk about documents, I mean every important document related to your child's education, medical, extracurricular activities, and those sorts of things. If it's important, don't put every document possible in there, because remember, you want to keep it simple, but you want to show that you've got access to that information and it's right there if the judge needs to look at it, if it supports some aspect of your particular case. Okay, tip number 3, support your position with Illinois law. Okay, now so far you've given the judge a parenting plan and you said, Judge, this is what I think should happen and this is why. Okay, in there, I alluded to this earlier, but for your requests, it is so helpful to a judge to know that your request is premised on the actual law the judge is to follow. So go back and read the law that I referred to earlier, and where it talks about different aspects of what is in the best interest or the factors for the best interest of a child. tie your request to each of those factors. Okay, so put those in there. And for each one, say, here's what I'm asking for, and here's the law that supports it, Judge. When you can do that, the judges, that's less they have to think about. They can see clearly, oh, this is what the litigant or the party is asking for, and I can see how the law supports their position. Therefore, I can use that as justification for my judgment, my final ruling in this particular case. It's like going into a foreign country and speaking their language. If you've ever been in a foreign country and you go talk to someone and you know just a few phrases maybe in their language and you can say them, you always see them perk up, pop up like, wow, that's great. You took the time to understand my language. When you're giving the judge the law and you're supporting your request with the law, you are now speaking the judge's language. Again, go to 750 ILCS 5/602.5 to 0.7, where you're going to find everything I'm referring to there. Okay, tip number 4, demonstrate reasonable behavior. Okay, so let me set the picture for you. You're in court, and let's say your court case is going to be called at 10:30, okay? And so you show up at the courtroom, and you show up early. Okay, please do that. Show up early to the courtroom, and you're there on the outside, on the wall. There's usually this like board, and pinned to the board is what's called the docket. Now, the docket are all of the cases the judge has that day. And if you're at 10:30, you're going to see cases before yours, and you're going to see cases that are going to be called afterwards. And they're going to be in re the marriage of so-and-so and of so-and-so and that sort of thing. You're going to see all of those folks that are there for court. What that's going to show you is, A, the judge is busy. There's a lot going on. Okay, and so the judge has a limited amount of time to see the parties. And it's so important that that limited amount of time, that small window of opportunity, you are presenting your best face to the court. They need to see someone who is reasonable in their demeanor, in their conversation, in their nonverbals, and how they communicate, how they hold themselves. That short period of time has an inordinate impact on the judge's ruling in a case, because that's all the time they usually get to see people is in those short periods of time. Or if there's a trial, then it's a longer period of time. And I've seen one thing, I've seen it dozens of times, hundreds of times. The judges favor parties who are reasonable in how they communicate, what they ask for. They're not overreaching. They're not bullying of the other party. The judges are looking at that and they're weighing all of that to determine a party's credibility. So here's what that looks like. Okay, that means you documenting all attempts that you've had at reasonable communication with the other party. So you can show that to the court. Now, a lot of times that's text messages or emails, or if you're using an app to communicate with the opposing party, you've got that there to show the court. And the judge can look at all that stuff and see, okay, yeah, I can see where this party is trying to be reasonable and how this party responded pretty cruelly and pretty mean. And they did some really nasty things. And you don't want that to be you. So showing that you're very reasonable in your communication and documenting that so you can give that to the court is extremely helpful. Another thing is being very flexible in your scheduling. So you're going to have a schedule, most likely. It's one that you've either agreed to or the court has ordered. And if you have a schedule, it needs to be modified because you know how it is. Life gets in the way and kids got different things going on and parents got different things going on. And they need to move it around a little bit and change things a little bit. If you've got flexibility there and you're showing that your willingness to accommodate the other party, even if you're upset, even if you're mad, even if you know the other party's doing things just to kind of tweak you and push your buttons, calming it down, slowing it down, and being flexible in that scheduling is going to show that you are more reasonable, more to be trusted once the judge doesn't have oversight. Okay, so that's real important. Another thing, this kind of goes without saying, it kind of referred to it a moment ago, but be respectful in your attitude toward the other parent. The judges are geared to pick up on that and they sense it. And certainly if there's a guardian involved, they're going to be looking for that too. So be respectful in all ways as you can to the other parent. Keep a record of all of your joint decision-making efforts. So if you and the other parent are arguing about where they go to school or some extracurricular thing or whatever, keep a record of all of your efforts and your attempts at communicating that, accommodating that, being flexible, compromising. All of those things are important on those joint decision-making issues, okay? Because if you and the parent are not able to get along and make easy joint decisions. The court is going to give it to one of you over the other, and you want that to be you. So you got to be reasonable, calm, and very accommodating toward the other parent as you go through the process. Also, be prepared when you go into court to talk about co-parenting strategies. The judge may just pop a question on you. What would you do? Or how would you handle this? Or how will you handle this? Or how did you handle that? Those sort of things that get to the idea and get to evidence around co-parenting is real important for the judges to look to. Okay? So really, in summary, just understand that the judges see so many high conflict cases, and you don't want them to remember you as one of those parents who just kind of falls into that high conflict, emotional impact, full of just argument and acrimony sort of parties. You don't want to be that person. You do want to be that reasonable parent who puts their children's needs first above their own needs in whatever form that shows up. Okay, tip number 5, make complex information simple. Now, this is a variation of what I shared earlier, okay, where I talk about making things simple, bottom shelf, and accessible for the court. But you're going to be tempted to want to throw everything in there, and it can get very complex and overwhelming to someone who doesn't have and will never have the fingertip mastery of the facts and details that you do. So make everything as simple as possible. And that takes a lot of work to lower things or slow things down, make them very simple for the judge to understand factually and chronologically what took place. Now, that may require you to make clear, concise summaries of each of the sections in your parenting plan, for example, or that may require you to create visual aids. If you need to demonstrate something, having a visual aid that's thoughtful, time has gone into it. It's easy for someone who doesn't understand what's going on to look at it and to understand it. That could probably mean, and I think this is a best practice, to have the visitation or the parenting time schedule all laid out and very simple by a month even, okay, saying this is the overnight that I will have the children, or this, whatever those details are for your particular schedule, having that laid out in a 30-day or 4-week rolling format to give to the judge, making a complex schedule very simple, will certainly aid you in your case. It could also mean that you may need to create better visual timelines for the judges to look at, laying it out in detail from a visual standpoint so the judge can at a glance see, okay, that's what happened. That's what happened. That's when that happened. Now I'm getting the pieces in my head. Okay. So making all of those facts in your life that can, to the outside person, can be very complex to understand and put into categories, categorizing all that, making them very, very simple and boil them way down to the essence, make them concise. I keep repeating this because it's so important. I've seen so many clients come in and dump things on my desk that have just been overwhelming to me. And I am way more familiar with their case than the judge would be. And I've seen clients in court, not my clients, but other clients in court, throw stuff on the judge that just overwhelms the judge. And I could just feel it like, oh my goodness, I can't sift through all of that information. And so the judge typically just doesn't. So I hope those 5 tips will really help you go into court and be prepared and get the best possible outcome in your case. Now, sometimes there's a guardian involved in cases. And if there's a guardian involved in your case, then you need to be prepared for what the guardian is all about, the guardian ad litem. So go to this next video over here, and I'll see you over there as we talk about what a guardian does in a case.